Morning, everyone. Okay, we're gonna get started. I'm Matthew Cherry, Senior Counsel for TABC. And at today's stakeholder meeting, we do have a number of items. Specifically, we have three draft rules and then one kind of amended advisory. And before I kind of dive into everything, I do want to just explain a little bit of the lay of the land here in regards to the draft rules. And just for clarity, these are discussion drafts in order for the agency to receive feedback. None of these drafts have actually been proposed yet to the commission. Our goal is to propose drafts at the September commission meeting. However, once that happens, there's also then going to be another formal comment period before anything gets adopted. So this is not your only opportunity to look at any drafts and then provide comments. And with that said, we would like to have everyone try to do their best to provide any feedback by September 1st. That way there's some time to have internal discussions with staff, make any adjustments to text that's needed before we propose anything to the commission. And then lastly, please be mindful that especially with the contract distilling and alternating proprietorships for distillery rule, I know people may have a lot of questions. I may not be able to answer every question because depending on the specifics of it, it may be something that I really need to take back to staff to have a discussion before we can get anyone an answer. So with that said, we will start with agenda item 1, which is a proposed rule draft for distillery operating agreements. So what I'll do is I'll just kind of give an overview of each subsection of the draft rule and then allow everyone to provide any sort of comments or feedback that you have. So starting with that, we'll look at subsection A. This one's pretty simple. It just states the primary 2 code provisions for these arrangements. And then in subsection B, we've defined the 2 types of arrangements. And what we did here really is to try to use the concepts that the legislature's already used for operating agreements for malt beverages. We felt that there was a lot in those definitions that kind of comported with what we're trying to do here for distilleries. And then in subsection C, we provided a definition for the term affiliate as used in code section 1410 and 37.011. I do want to stress that this term does appear in other areas of the code. And all we're doing here is defining the word affiliate solely as it's used in these two sections of the code, as well as anywhere else in the draft rule. And then moving on, subsection D, as in dog. All this does is clarifies exactly who must be a party to the agreement. I think especially when you read section 37.011 of the code, the language is a little bit slightly kind of confusing in who has to be a non-resident seller and kind of their affiliate who needs to be a party. So we try to add some clarification about that in subsection D. And then subsection E, as in Edward, what we've done here is try to clarify that the distiller who provides services on behalf of another distiller, they may not consider that product that they're making for someone else to be their own product, and they also may not sell that product at or from their premises. And then subsection F, this clarifies that product that's manufactured by another distiller may not be brought back to the owner's premises and sold directly to consumers under section 1405 of the code. And here, when we're talking about, manufacturing, what that really is referring to all of the main processes involved in actually creating the liquid alcoholic beverage product, not necessarily all of the ancillary kind of activities that go into getting the product to the market, such as, bottling. Right here in this subsection, when we're talking about manufacturing, it really is the actual kind of distillation or rectification processes. What's being done to actually manufacture, create the liquid alcohol. And then in subsection G, we've done this to kind of make it clear that product that's produced under or pursuant to an alternating proprietorship, that may not be sold to the consumers under section 1405 at that host distiller's premises. And then in subsection H, this does relate to subsection F, but it's somewhat of the inverse. So in this case, if a distiller is actually manufacturing, again, that liquid, doing the distillation or rectification of the distilled spirits, if they do that themselves, but then maybe under a contract arrangement, they have another party, another distiller actually do the bottling or the packaging and labeling of the product, then in that instance, that distiller that did the manufacturing can bring that product back to their premises and sell it to ultimate consumers under section 1405 of the code. So the big distinction between that and subsection F is if someone else is doing the manufacturing, you're not going to be able to sell it back to the ultimate consumers on your premises. If you do the manufacturing, but then someone else does one of the other kind of ancillary activities, then that does allow you to bring it back to your premises and sell it to ultimate consumers. And then moving on in subsection I, what we've done here is just try to outline the specifics for the agreements that must be submitted to the agency. I do know right now, currently in the rule, it doesn't state exactly where to submit those. We're having some internal discussions about that, and we'll post some stuff on the website once we get final rules to give people guidance on exactly where to submit those. And I know ultimately one of the things we want to do is, allow people to submit agreements via AIMS. And I believe right now, the only way that's done is if it's happening concurrently with actually applying for a license or a permit, not necessarily after you've already received one. So that's something we're working on. But until then, we'll have a designated area, most likely an email address with a division within TABC that you can send those agreements into. But I do recognize that right now that's not in the rule, but we'll provide additional information in the future about that. Okay, and then in subsection J, we've done here is added a requirement that non-resident sellers who are engaging in these activities through an affiliate must submit an affidavit to the agency along with that agreement that they sit in. And that affidavit just really has to kind of prove up the qualifications to be an affiliate, as we've defined that in subsection C of the draft rule. And then lastly, in subsection K, we've essentially added an exception to the current rule 45.26. So what we're doing here is authorizing the distilled spirits to be transported from one premises to another when that's happening under a contract distilling arrangement or alternating proprietorship before the product has been registered with the commission. We felt that this was necessary because as of right now, rule 45.26 does prohibit that product from being removed from a premises at all. And it actually also says, even before it's bottled, that it has to have product registration. But we also recognize that in these instances, some of that product's going to have to leave a premises under these arrangements to potentially be submitted over to TTB, either for formula approval and or to eventually get a COLA. And because that's a prerequisite to receiving TABC product registration, we figured there needs to be an avenue for that to be able to happen to kind of get with the feds, obtain your COLA, so then you can actually go and get TABC product registration. So that's what we've done in subsection K and add just an exception to current 45.26. All right, and as of right now, that covers all of the subsections that we have in the draft rule for this. So I'm going to open the floor to any questions or comments.
Hi, it's Amber with the Texas Distilled Spirits Association.
Hi, Amber.
Hi, just want to clarify on F. So what you're saying is if a distiller has their product actually manufactured at another location, right? Even under a contract, even whatever, that they then can't sell that product that was manufactured at a different location in their tasting room.
Correct. Yes, that is exactly what we're saying here. And some of that is based on the actual language that's contained in section 1405 of the code.
Right. Got it. Just wanted to make sure that I was clear on that.
Yep, absolutely.
Good morning, Matthew. Amy Harrison here.
Good morning.
I just pondered, if I'm a distiller and I'm making several brands, perhaps dependent on the situation, I might be contract distilling for one brand and alternating for another brand. How would that work? Or how? I just am curious.
Well, okay. I mean, I guess essentially that could work out because you're not required to only, engage in one of these kind of types of arrangements. So I guess conceivably you could do one for one brand that you have, and then maybe that's a contract distilling arrangement. And then for another brand, you're operating and kind of producing that through an alternating proprietorship. As we've kind of done the draft rules right here, there's nothing in there that would, prohibit you from engaging in both for different brands, as long as for each brand and how it's being produced, you're following, the rules.
And would you envision that I would have to report that by brand in getting my approvals?
Oh, so, okay, when you mean that, do you mean, I guess, report by brand for like sending in the agreement, that type of approval?
Correct.
Then in that case, I would say yes. We'll, I'll obviously have some more discussion with staff, but if I'm understanding everything correctly, I would say then yes, because you're going to need, an individual agreement for each arrangement that you're going into. And if that arrangement does cover more than one brand, I think that's fine. But then if you're going to have different arrangements for different brands, then you would need to submit different agreements per brand.
Thank you.
Absolutely. All right, I'm not seeing anything in the chat. I'm going to move on to the next agenda item. But if you're still thinking about any kind of questions or comments, at the end of this, I'll go back and, feel free to make additional comments on this item 1, even though we've kind of moved on. So next up is item 2, which is some draft rule amendments to chapter 45. This is pretty kind of basic here. So one thing that we noticed in 45.2 for the definition of distilled spirits that did not exactly kind of fully align with the definition that's in the code. So we've done an amendment here to actually just track the language that's in the code for the definition of distilled spirits in section 104. I think it's 104 subsection 3. So now all that's doing is just literally just tracking that exact language from the code. And then next in draft 45.28 and draft 45.29, what we've done here is added back in standards of fill. The kind of standards of fill and container size requirements, those were in a prior rule. However, that rule was repealed after sunset, and the ledge made some statutory changes to our product registration process and us just adopting a COLA. After that time, we thought that the rule was not necessarily needed. But however, we have had some recent kind of questions about this topic. And so we did think it was kind of prudent to bring that old rule back and then also just make it very clear what exactly is allowed in Texas pertaining to container sizes or standards of fill. And all we've done here with these 2 draft rules is just to try to make it clear that any of the container sizes or standards of fill that are authorized specifically in the code are allowed, as well as any of the container sizes and standards of fill that are authorized by the federal government. I know recently TTB did some updates with the standards of fill for distilled spirits. So we've tried to use some language that just piggybacks off of the areas within the Code of Federal Regulations that those would appear in. That way, if, in the future, I don't know, in the next year or so, they add some additional container sizes or standards of fill to distilled spirits and or maybe, wine or something else, this rule will make it clear that once they do that, that's also then going to be authorized and allowed in Texas. And we feel that just makes it easier, especially because right now for distilled spirits and wine, we just basically adopt that COLA for product registration. So that covers item 2. I'll open the floor for any questions or comments on that one. All right, I'm not seeing anything, so I will move on to item 3. So here is some amendments to Rule 41.12 for compliance reporting. There's really only, I would say, 2 kind of main modifications here. So what we've done first, and you'll see this in subsection C, is we've extended the allotted amount of time to actually complete those compliance reports. And that's moved up from 90 days, and we've actually doubled it now to 180 days. And then the second thing that we've done here, you'll find in subsection D. And so these amendments also modify when the agency will actually go and pursue an administrative violation after someone receives a written warning for a failure to complete that report within the 180 days. Currently, or in the current rule right now, if you get a written warning, it says the agency can go and start and make an administrative case against you if you did not, actually go back in and complete that report that you got the written warning on within 30 days after that date. So now instead we've kind of extended out that time period and instead said, hey, if you miss this 180-day time period, you're going to be issued a written warning. And then after that, if your next compliance report, you actually also don't complete that one, then that's at that point in time is when we'll actually go in and start to pursue an administrative case for that type of violation. So those are the only 2 changes we have with Rule 41.12. And I will open the floor for any questions or comments on that.
Thank you, Matthew. This is Amy Harrison again. In B, as long as this is open for discussion, if B could give some more clarity about with the commission as instructed by the commission. In the last compliance reporting, there was a lot of confusion about who was required. And then I think the wording was changed to who was eligible. And if we could get clarity, for example, a permit's originally issued in December 23, does it have a compliance report due to the commission in January of 24? So if we could get more clarity in B about who must prepare and file the automated compliance report, that would be very helpful. I'll get you some suggested wording, but it I believe in this last experience that it would have been very helpful if we could have gone to a rule to see who actually was required to file a compliance report. So I'll get that to you, but that's a thought.
Absolutely. Yeah, no. Any suggested language would be really helpful. And I totally hear your point on that, and adding maybe some language in there that makes it clear about who actually has to do the report and when, instead of just maybe using the word instructed by the commission. So we're happy to take a look at that and kind of make some adjustments as needed.
Thank you. And
Absolutely.
there's a lot of hard work here, and I just want to point that out and say it's very appreciated.
Well, thank you. We appreciate that. As you already know, compliance reporting is a complicated topic. All right, it seems like that's it right now for item 3. So I'll move on to item 4. So what this is revisions to the current marketing practices advisory number 19 for private club advertising. This does look, I feel like, a lot different than the current one, but I will say a lot of it is just kind of, we've reworded everything to make it a little bit easier to read. And we haven't really tried to change the substance of anything except 2 big things that I will go over. And outside of just rewording stuff, the other kind of main change is just we've added in some additional information on kind of the definition of outdoor advertising, what actually qualifies as outdoor advertising. And that really just tracks what's already in the code in chapter 108. And then the big kind of 2 changes that we have done with this revision is you'll see the first one on page 1 at the bottom here pertaining to advertising in a partially wet area. So the prior version of the advisory, we felt that it could be read to potentially not fully align with current rule 45.105 and specifically subsection B, subsection 3. And so currently what that rule states is that private clubs may advertise any class of alcoholic beverages in an area where the sale of that class of alcoholic beverage is legal for on-premises consumption. So if you're in a partially wet area and you want to advertise, the type of alcohol, whether that's going to be malt beverage or distilled spirits or wine, you can do so as long as that area is wet for the on-premises consumption. The language in the prior advisory was not very clear about that, so we just wanted to reword that, add clarity, and make sure that the advisory fully aligned exactly with what's in the rule. And then the second kind of big change you'll find on the second page, and it's really in the kind of 2 examples that cover permissible kind of outdoor advertising placed on the premises. If you'll notice in the kind of second half for the prohibited statements, that used to actually have an additional example that we've now moved up into the examples above it for stuff that is permissible. And what we were looking at here is previously the example didn't state an actual like monetary price, like $1, $2, 50 cents or anything. It used the word price and said, I believe, half off or half price happy hour. And so we looked at there is, okay, well, that really doesn't align with the current rule about not stating a price, because if you just use the word price, we don't feel like that is a violation of the rule and that is, permissible. So we moved that up to show that that is going to be something that is allowed. What's not allowed is actually using any sort of, monetary amount, an actual like $2 off. We'll look at that as a price, not just using the word price. So that's the only other big change that we've done with this advisory. Oh, and I'll open the floor for any questions or comments. All right, I'm not seeing anything. So now at this time, that does cover all four of the items on today's agenda. But I do want to open the floor in case anyone did not get a chance to provide a comment or ask a question on any of the agenda items. All right, I'm not seeing anything. Okay. That kind of concludes everything that we needed to go over in today's stakeholder meeting. But I do want to say today was not the only time to provide any comments, questions, or feedback, especially on the draft rules and the advisory as well. The advisory, I will add, that was published in the August 2nd edition of the Texas Register. And as stated in there, we'll accept comments through September 1st before finalizing that advisory. And then when it comes to the rules, again, these have not been submitted yet to the commission. These are just discussion drafts. Our goal is to try to propose something in September to the commissioners. However, that, is somewhat dependent on the type of feedback that we get. And so in order to kind of fit within that timeline, our request is that if you have any sort of additional comments or feedback on either or any of the three draft rules that we have, try to submit those by September 1st in order to give staff time to have internal discussions and then make any adjustments to the language that we need to. And all of those comments can be sent in to rules@tabc.texas.gov if it's for agenda items 1 through 3, or if it's the fourth agenda item for the advisory, you can submit comments, questions, and feedback to advisories@tabc.texas.gov. You can also mail those into the agency's PO box, and that is listed on the website. And it's also, I can just state it out loud right now, it is PO Box 13127, and that's Austin, Texas 78711. All right, and that concludes everything. I'd like to thank everybody for your time today. We look forward to continued discussions on these drafts. Thank you.